back in session. I would just like to let the members know that in your today's agenda, if you're seeing that item number 10 that's still there has actually been moved down to the third reading file, and that should be on page 14 if you notice as item number 28. Okay, so that has gone down. So we recessed yesterday at about 5, and we started at least with the acceptance of Bill 195 by Senator Ugwin. And so, Senator, you still have the floor.
Good morning, Madam Speaker, and good morning to all of our fellow colleagues and to all of the staff members of the legislature. Madam Speaker, I want to thank you very much for allowing me to initially open up with the discussion on Bill number 195. And just for the information of our colleague, it's the originally introduced version. I want to just say this first and foremost, thank you very much to all of you for allowing me to be able to place this on the agenda. I know that there's going to be perhaps some lively discussion in regards to this legislation, but I think that I've shared to a great extent my perspective in regards to hopefully getting it through in its present form through this body. Madam Speaker, this is legislation that had previously been introduced in a prior legislature, and it's a model off of a template that has been utilized by over 25 states in enacting Born Alive Infant Protection Acts in their respective jurisdictions. And I highlight that primarily because these 25 jurisdictions have recognized that, in fact, the 2002 Born Alive Infant Protection Act does not reach into the respective state jurisdictions, with the exception of federally financed healthcare facilities as well as medical facilities or medical facilities that are receiving federal funds. So that's one of the reasons why most of these jurisdictions of the 25 that already have enacted Born Alive Infant Protection Acts, very similar in nature to this that we're discussing this morning, have enacted that. Just a couple items on that particular note. First and foremost, as a federal law, the 2002 Act, because I know that act was referenced during the course of the public hearing and highlighting that it's a federal statute and it would be applicable to Guam. But these are some of the information that I've been able to glean over the course of the last few weeks in terms of preparing for this overall presentation. As a federal law, the Federal Born Alive Infant Protection Act only applies in limited circumstances. For example, the federal provision would only extend to those hospital and employees operated by the federal government or which receive federal funding. It will not prohibit private or state-operated clinics and hospitals from denying care or medical attention to born alive infants. Second, states can enact versions of this similar provision that are more comprehensive and protective than the federal version, and we all know that. And then also, lastly, state versions of federal laws function as reinforcement mechanisms for their federal counterpart. Madam Speaker, I introduce this not only because obviously whenever you introduce legislation, you need to be able to support the concept, but I introduced it because of what the nature of this provision provides. It provides that should an abortion take place and an infant come out alive, then that infant should be recognized immediately as a human being, not as part of the continuous process of the abortion action on the part of the physician. And just based on that premise, if that infant who comes out during the course of an abortion is alive and is recognized as a human being, there are only natural steps that have to take place in terms of making sure that that infant is given as much medical attention as possible so that he or she can be able to live their respective lives accordingly. Madam Speaker, I say this with acknowledgement that there was an example of a situation such as this a short while ago of an infant that apparently was going through, or the mother was going through an abortion process, and an infant came out alive. And to the benefit of the infant, that infant was given immediately the medical attention that it needed. And I'd like to read the story about that abortion survivor, because I think that this says a lot about the possibilities of protecting life once that infant is brought into this world. And this is about is a story from a gentleman by the name of Carey, Mr. Carey, and his daughter Caitlin. His excerpt, and it's included in the committee report, it says, "Our daughter Caitlin survived a late-term abortion attempt by a young woman who ingested pills issued by an island women's clinic. Instead of inducing a spontaneous abortion as intended, the woman went into labor, and a friend had the presence of mind to drive her to GMH, where she delivered a live 3.5-pound preemie and subsequently abandoned her there. Through the good offices of the social worker as well as the religious leader, they took the child into their home at age of 34 days. After 3 court appearances over the next 8 months, she officially became his daughter, he and his wife in this case. The girl is a bona fide miracle child. Not only did Caitlin escape the welter of medical issues one might expect in a child who entered the world under such adverse conditions, she emerged as a beautiful island girl, healthy, athletic, and startlingly intelligent. Nothing, and he's referencing his wife, nothing Chris and I take genetic credit for, but we consider ourselves blessed for the privilege to raise such a child." And in this case, Madam Speaker, it goes on to highlight that Caitlin, at the age of 7, makes straight A's in the 2nd grade, and now she's relocated with her family to South Carolina, and she also successfully tested extremely well in her taekwondo and her karate classes. That's an example of what this legislation could do in terms of being able to save a life. Madam Speaker, if I can highlight some of the provisions contained in Bill 195-32 COR. Section 1 is the legislative findings and intent, acknowledging that this is legislation that was introduced in a prior legislature. Section 2 is the establishment of the Infant Child's Right to Life Act, which provides the title and then obviously all of the provisions. The first subsection is the legislative findings and purpose, and I wanted to highlight a particular section there where it reads, "It is the purpose of this act to ensure the protection and promotion of the health and well-being of all infants born in this territory. Therefore, this act mandates that healthcare providers give medically appropriate and reasonable life-saving and life-sustaining medical care and treatment to all born alive infants." It also, the next subsection are the definitions, and within the definition, subsection E defines the word infant for purposes of this act, and as used in this act means a child of the species Homo sapiens that has been completely expelled or extracted from his mother, regardless of the stage of gestational development until the age of 30 days post-birth. An infant is also a human being for purposes of Chapter 16 of Title 9, Guam Code Annotated. And if you're inquiring or you have questions about what Chapter 16 of Title 9 Guam Code Annotated references, it's the criminal homicide provision for our territory. The next subsection are the requirements and the responsibilities. Subsection D highlights the physician performing an abortion must take all medically appropriate and reasonable steps to preserve the life and health of an infant. If an abortion performed in a hospital results in a live birth, the physician attending the abortion shall provide immediate medical care to the infant, inform the mother of the live birth, and request transfer of the infant to a resident or on-duty or emergency care physician who shall provide medically appropriate and reasonable medical care and treatment to the infant. Subsection F on page 5 goes on to read, any infant, including one born in the course of an abortion procedure, shall be treated as a legal person under the laws of this territory with the same rights to medically appropriate care and treatment and birth and death. If death occurs, certificates shall be provided accordingly. The next subsection deals with criminal penalties, and I know, Madam Speaker, this is a section that was brought up during the course of the public hearing as a serious concern. And it reads, any physician, nurse, or other licensed healthcare provider who intentionally, with premeditation or intentionally or knowingly or recklessly or by criminal negligence fails to provide reasonable and medically appropriate and reasonable care and treatment to an infant in the course of an abortion shall be guilty of a criminal homicide as defined in Chapter 16 of Title 9, Guam Code Annotated. Madam Speaker, I did highlight already the provision for Chapter 9, Guam Code Annotated. The next subsection deals with civil and administrative action, and then finally the construction. And this is where I think not only have all the jurisdictions within the 25 states that have enacted Born and Life Protection, Infant Protection Acts, have this particular clause which says and stipulates that nothing in this act shall be construed to affect existing federal territorial laws regarding abortion, and it also has other provisions in there. Madam Speaker, I certainly look forward to the nature of this discussion. I think that my position has been, because this is a similar template of what has been nationally through the 25 states been enacted into law, that certainly making adjustments or making significant deviations from the provisions contained therein, I think you will not find me in support of doing that. And let me just close my opening statements, Madam Speaker, with all due respect to all of our colleagues. And we understand the nature of how principled we can be on certain issues. And I respect every single individual's position in here. And I look forward to the discussion. But to me, there was a heated discussion, not a heated, perhaps maybe an active discussion between myself and a senator in this room, and that individual knows exactly who that person is. But, Madam Speaker, the question that was posed to me was, you're going to impose homicide criminal penalties for physicians in this particular case if an infant comes out alive. And my response during that conversation was, yes, the provision provides for it, but my perspective is and will be during the course of this discussion, and has been for my life, my entire life, is that if that infant comes out alive, that infant is a human being, Madam Speaker, and that infant should be cared for and tended to like any other human being in terms of the responsibilities of this community and this territory, and that is to protect, do everything they possibly can. The physicians or the assistants or whoever is around that particular infant, do whatever he or she can possibly do to protect and to preserve that life. And I think that that is really the underlying concept behind this particular measure. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, is there anyone who would like to speak on Senator Agun's motion? Speaker Pangilinan.
Thank you very much, Madam Speaker. Madam Speaker, it's very, very obvious that the issue that is to be addressed here is really a very personal issue that touches upon a segment of our community that I really, have no personal stake in it. I think that this personally affects the lives of women in our community, of course, families with husbands and boyfriends and relationships of women of childbearing age that may be faced with this type of decision, and their ability to access medical care, including what has been determined to be the law of the land, the right to access the termination of that pregnancy, provided they meet the parameters of our Constitution and the rights affirmed to women by law in our country, and by that extension, our island. And it touches the lives of doctors who spend untold years and almost at times unsurmountable debt to go into the art of the practice of medicine to render medical care as a profession, an avocation, and as a service to the people in the communities that they invest in, and putting up practices to provide that medical service, both in areas that are underserved, as Guam is, and the ability of our community to attract service of these doctors to provide and make adequate care available at the minimum to our community residents. And so the issue is both emotional for the families and those that are affected of it, the women, economical in some respects to the doctors that decide where they're going to practice, where they feel that they have the protection of law to ensure that they can practice medicine according to what they spent years and years and years working on, studying for, and rendering. And when we have laws that, in my opinion, and the opinion of the doctors, much more importantly, the opinions of the doctors themselves, feel that it inhibits their ability to practice and it places great risk, both personal and family, for themselves, then we need to take look at those laws and make a determination whether we in here consider what's at stake for all of these segments of our community and try to balance what exists in law today to provide the protection for the women and the babies that are born live after an attempt at a termination that results in a live birth, and other existing statutes that provide the remedies necessary to protect those women and those babies that are born live in an attempted termination. And from what I can tell from the testimonies provided, that we do have adequate laws in place both at the federal and the local level that protects the rights of these women and the rights of these families to not only ensure that when the attempted termination of that pregnancy results in a live birth, that not only have the doctors come together in this community and looked at and studied policies necessary to guide their practices, for example, in this case at Guam Memorial Hospital, where these doctors are credentialed, and in order to practice in the community, they also are credentialed at the hospital and have to provide services at the hospital and are guided by those rules, regulations, and laws in the carrying out of their duty for their specialties, that it exists there as well. And these were developed, of course, by the doctors themselves, who understand what the risks are and what would be necessarily correct and proper remediation and action that must be taken, not should be taken, but must be taken by themselves and those involved in the process of providing that service that is a right to a woman for the decision she makes with regards to what happens to her pregnancy. And so it kind of, for me, means that we're coming in here now and negating all of that according to the doctors, according to the interpretation of the existing statutes, according to what these doctors have agreed to, that in order to practice medicine at Guam Memorial Hospital, they will bind their practices and their decisions in rendering the appropriate care should a termination of a pregnancy result in a live birth. And so, while I fully support that that care must be given, as well as the doctors who presented testimony fully support that that care must be given, they believe that what is being presented to us in the legislation before this body today interferes with that and is unnecessary, and that what occurs and what puts their ability to practice what is in their professional training at stake. That the determinations and what are the requirements of the statute here go far and beyond what is necessary to provide that medical care that must be rendered to a live birth that results from an unsuccessful termination of a pregnancy. That all the parameters are there to ensure these protections. to the families, to the baby, to the doctors, and to the community. And so I look at what this presents, and I feel that considering all of those issues as I look at them, they continue to remain consistent with my personal position on this matter, even though I don't have a personal stake in it. But I do have a stake in it as a member of this body that will set the policy for our communities, and considering all of the interests involved for those that will be affected by the policy that we are being presented to enact in Bill 195. And I don't believe that it's balanced, and I don't believe that it renders anything additional, with the exception of putting members of our community at risk. That if for whatever reason, which is what we have seen has occurred in the past, when the protection of that woman's right to make a decision regarding her birth and the ultimate outcome of her pregnancy, and that she wishes to exercise her right to make that decision within the guidelines. It's not an unfeathered decision. It's not a decision that ignores the right of what results and when what occurs with that pregnancy results in the need for this country and the need for lawmaking bodies to step in and say, there is a point when you no longer have that right. So it's not an unlimited right, and the women have come to recognize that and accept that. That at some point, there has to be protection rendered to the fetus. So we're not doing anything at all here that changes that there is protection guaranteed to that fetus. But at certain point, that right does not exist and belongs completely to the woman and to those that she consults with, her doctor, her pastor, her husband, her boyfriend, her family. But it leaves that outside the realm of the government, in which the government does not, and I believe should not, have a right to step in and interfere at that point until this government has set the policy of when there's a community interest in protecting that fetus. And everybody has come to accept that. What this will result is that the government is stepping into that element where it already says you don't have a place. That doesn't belong, government doesn't belong in that time frame for that decision. And when you inject government into that time frame, what you will have is an interference of that personal right that the woman has, confined with how broad she wants to make that decision be influenced. But it's her decision on who should influence her doing those decisions. It shouldn't be the government, and it shouldn't be the law. And when that occurs, Mr. Speaker, and until the government had stepped in and provided that point at which that decision must be taken out of that time frame and that realm, and must recognize then the fetus and the rights now that are attached to that fetus as they move on to the completion of that pregnancy, then we provide all the protections available. When this country did not make that decision, we had horrendous experience with what happened to women when that appropriate medical care was made available to them, when that professional medical care was made available to them. And we had a greater waste of human life then than we do now. This takes us back to those dark days and back alleys, when doctors, because of what we are proposing in here, are no longer going to feel comfortable or may want to place everything that they've worked for all their lives at risk to provide what is constitutionally a right to that woman to get professional medical care in her decision of what to do with her pregnancy. And so I just think that the way that the bill is written and what it proposes doesn't advance, in my opinion, the protections, because all of those protections already are in law. What it does is it opens that door that we have closed that have resulted in greater protection for what is constitutionally guaranteed for both mother and fetus as they proceed with what has occurred when a pregnancy occurs. And so it opens up that door for us to go backwards instead of us to move forward. And I don't think that presents to me a way that we should move forward on this thing without additional and greater thought on this issue and this matter. There will be disagreements, and there are disagreements. That is why every year we have members of our community in our nation and right here locally continually push for this issue on making that determination. And unfortunately, what determines for us of where our limits are is the Constitution, fortunately or unfortunately. And until we make those changes in the Constitution, then I think we have to continue to recognize what we call precedents in regards to how we can proceed with our own issues, our own moral dilemmas on how do we handle this. And those are debated under the legal structure that we have in the cases that are brought forth for reconsideration in the Congress, and when it happens in the Congress, for affirmation in the courts as to what is constitutional and what we are allowed to do in the interference and the limits that we place on our public citizens in their personal lives. And I think this goes beyond that. And we have advocates every single year, every single day, that advocate on a personal basis to try and convince our policymakers to go one way or the other to take that additional step and results in bills like this. I don't begrudge this bill coming forward. That is the advocacy that is also guaranteed by the Constitution. Advocacies for such issues as this, we must recognize and guard just as jealously as we recognize and guard what is already in statute that gives rights to individuals whose rights are going to be affected by this statute. I fully support bills like this coming forth. I just want to ensure that when the debate is done and the considerations are all discussed, that we don't step beyond the boundaries of what we are in here for and what we should be ultimately guided by. And that is what the legal authority, as reflected in the Constitution and amendments to the Constitution and the decisions of the court that guide those constitutional principles and sets limits and parameters on the constitutional benefits, on how far we can go in injecting government and its limits and its restrictions on things that are clearly provided in the Constitution under their private domain. And when we see clearly that it interferes with that, then the decision, no matter what our personal and moral position should be or is, that we have to also make sure that that is, if not the top, at the top of weighing ourselves. And if our intention is to challenge that, then there's a better bill that we can do to challenge that. This is not to do it. I mean, there's a better bill that should challenge that and settle that issue and settle that matter. Because some bills are introduced for the singular purpose of challenging the constitutional principles and ensuring that that bill passed by the local body moves up the ladder till it gets to the Supreme Court or the Congress and they arbitrate. And I just think that if this is the bill, then it doesn't accomplish that. It's not wide enough. It's not deep enough. And what it does, once again, is that until such time that we get there, it's almost non-enforceable. Non-enforceable. And if all we're doing is making a public statement, then maybe that's the basis of our vote. But if we're truly interested in protecting and advancing and ensuring that our local laws remain consistent with federal laws and constitutional principles, then we can't go with this bill. Because the unintended consequences of it, as I mentioned, drives women back to those dark days, which puts their lives at risk. The fetus who may be born in those back alleys and backdoor clinics presents greater risk of not being able to provide the service necessary to save that fetus life that results from an unsuccessful termination because of what this places at risk. And so, Mr. Speaker, I once again reiterate that I have no objections, no problem facing the decision that I'm being asked to face today with Bill 195, because that is the right of advocacy, and I fully respect all of those individuals who support and advocate for this policy. I just wish that they would grant the respect that we all deserve in the dilemma that faces us when we are asked to make the final decision on these things. You know, I received an email from a lady who I have seen her over the years. She is fervently in support of this. But the heartening thing about it is, you know, when she sent me an email, she just thanked me. She thanked me for seeing that in all the years, and she's been an advocate for this. This is not the first bill dealing with this kind of issue that's come before this body. But she said, Senator Pangilinan, I just want to thank you because over all the years that I've seen you address these issues that were presented to you, I have seen you never begrudge us because our advocacy results in you having to make a decision. I thank you for struggling with the matter. I have seen the personal anguish in your face, in your articulation of your position on these things, in injecting your personal experiences with this. I had a preemie. I have a nephew who's 23 years. Oh, I don't know how old it is. He is. I think he's 26, 25. 3.5 pound preemie. At one time, the youngest baby ever born here. And that was a personal decision. And don't think that my family didn't struggle with what the ultimate decision of that. Because truly there was a risk for both parent and fetus at that time. And our family gathered around her. She made her decision. We accepted what the final outcome could be. And we supported her. And thankfully and gratefully, by the grace of God and the mercy of all of our petitions, he's 26. Yeah. Would this have done anything for him? No. No, not at all. The right to make sure that that child or that fetus was protected is there in statute. Doesn't need this law today. They're telling us that the story about, yes, the same laws exist today as being told under that story. The same laws that resulted in all that is all in there right now to make sure that happens again. So maybe, Mr. Speaker, I think that one of the things that I would like to maybe have the body consider for amendment is that perhaps the doctors have said that their practice, their protocols, their professional evaluation of all of the issues relating to how do you treat a live birth are all embedded in the rules and regulations, or the Guam Memorial Hospital credentialing departmental rules and regulations. So maybe that's what we should allow, that be adopted as the standard for when care should be available and appropriate and exercised by the doctors. Let those professionals make that decision as they have already come together. So I'm not sure where that would be, Mr. Speaker. I would maybe just defer that I be given a little bit more time. We can continue the discussion. I don't mind listening. And then just be given an opportunity to make that possible. If I can write it up and be satisfied with it, I would like to reserve a little bit of time to possibly make that amendment later.
Because of the gravity of this issue, the chair will allow you to have a second opportunity to be recognized.
Okay.
And
Thank you very
so,
much.
I have Speaker Wampat and any other senator wish to be heard. Speaker Wampat.
Thank you very much, Mr. Speaker. Mr. Speaker, as you said earlier, that this is definitely a bill in which just can't be done in a few minutes, and it's definitely another a bill that hits you to the core. And one of the things that I think is important that everybody really take to heart, and to actually take the time to even, not just read the testimonies that were provided in the committee report, and look at it on both sides of the story. However, I know that when we do public hearings, it's always in the hopes that individuals actually come in and testify. And it's always been the practice of legislators to look at all sides, to consider it, and to even use comments provided, testimonies provided with, either with legal information from the codes that currently exist, or what does not exist, what some of the implications may be as well. But unfortunately, in this case, that didn't happen, and I, provide some discussion on that later on. But testimonies on one side was provided earlier, and no doubt that testimony was a very moving testimony. However, there are other testimonies that I think is important for the listening audience to hear, because we're only hearing one side because of what was provided, making it appear as if though that's the only testimonies that were provided. But testimonies from OBGYNs were at the public hearing. And as stated by the eloquent speaker, Pangilinan, is that at the hospital at least, there has been, and the hospital, the doctors, the administrators, the pediatrics department, OBGYN also have looked at this, reviewed the federal statute that protects infants that are born alive regardless of gestational age, or viability that was undertaken. And that then was a policy in which the speaker is going to talk about, which of course governs then the responsibilities of the newborn, its parents, and the community. So we have that in place, and I know I shouldn't be speaking about this, but it's definitely to support that. But as you know, to the doctors in their testimonies here, couldn't understand this, because in essence what is happening is that if there is existing standards already and regulations, federal law, which federal laws rather supersedes any local laws if we should do anything contrary to the law. But the way the bill is written, to me, and I'm not a physician, I'm not a medical professional, but to me it seems to have some of the language that already is covered in our criminal codes, but and what's also covered in federal regulation. But what this bill aims to do is to set up criminal and civil penalties directed against doctors and medical professionals who provide these type of services to patients who are in need of it. And doctors and all professionals, we know, take an oath to protect life. And I don't think there'll be a single professional who has not taken that oath. In addition, there are testimonies from the legal side of this community. And on the legal side, where we see the definition of infant as a child of the Homo sapiens that is born either completely expelled or extracted. Let me see, trying to find that page. But we have that here. Means the child, that's right, has been completely expelled or extracted from its mother regardless of the stage of gestational development until the age of 30 days post-birth. An infant is also a human being for purposes of Chapter 16 of Title 9 Guam Code Annotated. This exists in our criminal code. And, you know, and I was thinking about it, I said, that this is a victory in a sense by placing and legislating and defining what we call an infant. That's a victory, because what that says then in essence is that at any time, all doctors and medical professionals must then protect that child, save that child to whatever degree. But then, of course, the bill further provides that any physician, nurse, or licensed healthcare provider who intentionally and with premeditation or intentionally or knowingly or recklessly or by criminal negligence fails to provide reasonable and medically appropriate and reasonable care and treatment for an infant in the course of an abortion shall be guilty of a criminal homicide. That is also, with exception of saying a physician and nurse, but that in itself is provided in our statutes. Because Guam's criminal homicide law which is the 9 GCA, section 16.10, already exists and applies to an intentional or criminally negligent death of a born alive infant. So that's in our code. The federal law also applies to Guam, and it protects born alive infants. And the information that I was able to pull down, which is from the 107th Congress Public Law 207, and in that, and it makes sense actually for us in this legislation, is to do two things. Not to take the entire federal law, because we know already it is applicable to Guam, but I think what will be important to do here is to actually then, in this case, rather than just infant, but even person, where it is, and this is the biggest victory of all, because that's been a question and a debate for many years in the decision as if though to consider the person a human being. And in this case then, of course, in Congress's definition, is that it does say that the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who's born alive at any stage of development. That's the first section, first subsection of Section 8 of the federal law. And then Section B, as it is used in this particular section, the term born alive, and that's the definition, with respect to a member of the species Homo sapiens, means the complete expulsion or extraction of his or her mother of that member at any stage of development, who after such expulsion or extraction breathe or has a beating heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, regardless of whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean section, or induced abortion. And then it goes on to say again about that nothing in that section will be construed, confirm, deny, expand, or contract any legal status or legal right applicable to this. But then again, for those of us who attended the young professional meeting last night, and there was a question that really talked about legislations that this legislature or other legislatures have passed, and in terms of whether there could be some errors or erroneous language or even some serious implications. What this bill that we have before us was copied almost verbatim from a form that's issued by the Americans United for Life, except for the addition of the criminal homicide provision. And there's a problem with form legislation, and we know that. And granted, we look and research and we go and find some model legislations, and we like to then take it and actually apply it here to Guam. But sometimes the problem with form legislation is that there really is no real thought or regard to whether the bill is understandable or whether it should apply to Guam. So we're just using a form. And it's so funny because in the other bill where I tried to put a form in, and everybody fought here. I didn't get enough support. But oh no, we can't use that form. We must let them decide to do the form. Here we are now, however, saying the opposite. And and I've seen that time and time again. There's no consistency sometimes in the things that we present. So, I mean, I am baffled, of course, in terms of what it is that we're trying to do, when I think really this thing can be solved very easily. I think it can be solved with two language here. I mean, I know that Speaker Pangilinan is trying to put together an amendment, and I don't want to put an amendment that may be contrary to what he's also trying to do. But, you know, for me, it's basically what I think is important to do here in this bill is to actually then put in the federal definition of, in this case, I guess, because we're using infant, then that definition definitely is supported by not just federal regulation, but even Chapter 16 of Title 9 of the Guam Code annotated. And I think the second would be the language also of, again, born alive, and that everything is covered. Everything is there. But with the exception, of course, of this whole idea to go after doctors and medical professionals when these individuals have all taken the oath, no matter what the situation is to protect, preserve life. And what scares me about this, and I know that the previous speaker had alluded to this as well, is that there won't be any medical professional or doctors here who would ever provide these type of services. So what would our women do? They will go to butchers. Butchers. And what you're doing then now is you're endangering not just the mothers, but even the child. Is that what we want? Is that the kind of community we're going to turn into? So for my colleagues who are not listening, I know the listening audience are, and you need to know exactly what this body is doing that's going to set exactly what the policy would be for this island.
Thank you, Madam Speaker. Senator Nicholas, did I see your request to be recognized? You're recognized. Any other senator after Senator Nicholas? You're recognized, sir.
Mr. Speaker, I am a senator of the 32nd Guam Legislature. I am a servant of the people, and I serve them as a subject of the Lord. And what that means is that I must seek Him always, but I also must not abandon the free will that He has divinely granted unto me, to not be binded by dogma or doctrine, but to seek Him always. And it is through that, and only through that, that I have any courage, any wisdom, any energy, or any capacity to be able to serve the people. And while dogma and doctrine and rights can all get convoluted in this imperfect world that we live in, when I seek Him in the work that we do, and when I seek Him with respect to this bill, there are things that I'm absolute on and clear of conscience. And that is that we must, in all circumstances, save babies. And this bill, which was bravely introduced by the author, Senator Frank Uggan, is a bill to do just that. As the whole issue of abortion continues to linger on this earth, we at the very least need to be able to look at the situation and ask ourselves, at what point are we going to abandon what I inherently feel is our divine responsibility to save babies? What else are we doing here if not saving babies? What good is a balanced budget, paying COLA, pay for employees? What good is creating business opportunities and growing an economy, providing education, health, or public safety? What good is any of that if we're not saving babies? And in this bill, what it basically says, Mr. Speaker, is that if in the course of an abortion, a baby is removed from the womb and is still alive, by force of law, you must save that baby. And under criminal penalty, if you fail to do everything you can to save that baby, there will be consequences. That is something that I can absolutely get behind, Mr. Speaker. The question of rights. The question of federal law. The question of the Constitution. Those are all very heavy questions. And in the divine free will that we have been granted, we can approach each of those questions in our own way. And in my way of approaching those questions, there are some things that are absolute. Children for me are absolute. Every single thing that I am ever going to do in this body is going to be for the greater good of children, regardless of how old they are, where they live, whether it's in a tin shack, a concrete house, a 3-story home, or a womb. And all the work that we do here, in my opinion, is for naught if the care and the concern of a little baby that is taken out and is alive is less important than a doctor's profession. For me, this delicate balance, and I'm speaking strictly of myself here, this delicate balance of always seeking the divine, of maintaining free will and not being overrun either by dogma or doctrine, is the one thing that protects against the imperfection of human laws that could allow us to manipulate them to our own advantage. And we've seen that. I have seen that since I've taken office, and it has disgusted me, where existing laws are ignored or go unenforced or are manipulated in a way to benefit some and not others. And no human law can require somebody to have the conscience to follow other laws. That command of conscience that prevents corruption, that command of conscience that prevents greed, that command of conscience is divine. And in my surrender to that, as a servant of the people, means that they can count on me never ever going down those roads either. But in my surrender to that, my absolute surrender to that, I must also go down the roads that I believe in that very same conscience are absolute. And babies and life is absolute. Thank you, Mr. Speaker.
Thank you very much, Senator Nicholas. Senator Espicio.
Thank you very much, Mr. Speaker. Mr. Speaker, from the very beginning of this whole genesis of Bill 195, all I've been hearing, Mr. Speaker and colleagues, is that we want to take the federal statute and we want to make it applicable to our local laws so that whatever is a crime prosecuted under the federal statute, we want to provide for that same ability to prosecute those at a local level. And as we know, Mr. Speaker, the only way that we do that is we have to pass local laws that mirror the federal laws. And unless we want these laws to remain at the jurisdiction of the federal level, and we did that at one point with the counterfeit goods that we had to put in our code that's coming into Guam, and so it gives more prosecutorial teeth to go after those kinds of things. And I'm certainly listening to the whole reason for this bill. And what I'm hearing, Mr. Speaker, that we want to take the federal code and make it applicable in a local level by putting in the Guam Code annotated. It's not reflected in what Bill 195 actually sets out to do. For instance, if you look at the bill, on the definition of infant, it's very different to what the Congress passed as to what a definition of infant, and they describe it as a person, a human being, a child, an individual, as including born alive infant. And I think why they did this is so that if in the event a child lives after a failed abortion, then some measures need to be taken statutorily to protect that life, and it would be protected if we mirror the federal code. But what this proposal is saying is that the infant, for purposes of this act and as used in this act, means a child of the species Homo sapiens that has been completely expulsed or extracted from its mother, regardless of the stage of gestational development, until the age of 30 days post-birth. So does this mean that if the infant is struggling to live up until 30 days, and on the 31st day, this bill, if it becomes law, is saying that it's okay then to stop whatever means necessary to continue that life on the 31st day, on the 32nd day, 33rd day, that there's no law that's going to protect that child? And if we're saying that, then we're also taking away those constitutional protections that these families, and more importantly, Mr. Speaker, we're taking away the medical professionals' commitment to the Hippocratic oath that they swore to, that they're going to protect life at all means. And so what I want to do, and what I've always wanted to do, Mr. Speaker, for me, is make sure that everything we do is consistent with the Constitution, and until such time constitutional lawyers are able to overturn Roe v. Wade and the whole nation changes its legal position with respect to what those constitutional parameters are, then certainly at a local level we have to follow that. But at this time, I don't ever want to be part of anything that would result into more litigation, or in this case, be part of something that would take a very personal decision that's constitutionally protected, that women are protected by the Constitution, their families are protected by our Constitution, to make these very tough and painful decisions. And this bill just goes to the core of what those protections are. And so what I want to offer, Mr. Speaker, and our colleagues, is if we're saying that we want to take the federal law and we want to put it in our local statute, we want to recognize that that infants born alive after an attempted abortion, that they be recognized as a person, and that all the other laws in our books to protect the life of that person with the criminal codes and other stuff, that those laws will be there and it'll be mirrored after what we're really attempting to do here. So I want to offer a substitute to the bill to provide a new Section 1, and I made copies for our colleagues, Mr. Speaker, and I also want to say that all this underlined words here that I'm offering as a substitute to the bill are 100% consistent with the law that the United States Congress passed and signed into law by the President of the United States.
Has everybody received a copy of the proposed amendment? I see it being distributed. I see Senator Uggan's hand go up to speak on the amendment. I'll allow you, Senator Speaker, to finish after we've distributed. Please,
thank you,
continue.
Mr. Speaker, and I hope that our colleagues will be open to my floor amendment, and so that what we're doing here is exactly consistent with all the comments in support of Bill 195 and the reasons and the genesis behind Bill 195, which was to take the federal statute and localize it and codify it at a local level. And so I'm offering a definition of person, which is consistent with what the United States Congress passed, and we're adding it into words and terms defined in subsection 715 of 1 GCA. And the definition of person, human being, child, and individual as including born alive infant. A, in determining the meaning of any law or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of Guam, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any age of development. B, as used in this section, the term born alive with respect to a member of the species Homo sapiens means the complete expulsion or extraction from his or her mother of that member at any stage of development, who after such expulsion or extraction breathes or has a beating heart, pulsation of the umbilical cord, or defined movement of voluntary muscles, regardless of whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean section, or induced abortion. C, nothing in this section shall be construed to affirm, deny, expand, or contract any legal status or legal right applicable to any member of the species Homo sapiens at any point prior to being born alive as defined in this section. And so, colleagues, if we're really wanting to honestly mirror what the federal government has done, and if that's really the reason why this bill is being brought forward, then I certainly hope that the amendment would pass. Thank you, Mr. Speaker.
Thank you, Senator. Senator Uggan has raised his hand to be heard on the Respicio amendment. Any other senator wish to be heard on the Respicio amendment?
Thank you very much, Mr. Speaker. And first and foremost, I want to certainly thank our colleagues who have already rendered the discussion, at least at the onset, on this particular measure. I understand the nature of perhaps it venturing into an arena that I would never experience, and that is a woman who has to undergo and make some of these decisions. But, Mr. Speaker, I stand in opposition to the amendment because, with all due respect to the mover of the amendment, primarily because he states that, in fact, he's taking the same definition, the same words that are enacted in the federal statute and incorporate it into the proposed measure. Mr. Speaker, I want to say that 25 states have taken what is in this proposed measure, 195, and have enacted very similar wordings in their jurisdictions. As it applies to the jurisdictions of the states and as it applies to Guam, I would prefer to lean in that direction of staying with the template that has been accepted, has been adopted by 25 jurisdictions, states in the mainland U.S., so that in fact they can carry out the intent of this provision. And you know, Mr. Speaker, I hope that my comments are not taken as any disrespect, because what he's offering is something that perhaps would be palatable, but I'm leaning, like I said, in that particular direction in terms of going with the state jurisdictions rather than with taking the federal statute and that language. You know, Mr. Speaker, when we look at this, and there's been some comments that have been stated previously, and this is in direct relation to the definition of a child, and identifying that infant as a human being. There's been a lot of comments stated about Constitution and about whether, in fact, we want to move in that particular direction. And certainly there are constitutional rights that have already been recognized by the U.S. Supreme Court. These measures that have been adopted by the 25 jurisdictions, I'm sure have gone through similar legal reviews to ensure that they don't take away from that whole concept of the constitutional right that has already been decided upon by the U.S. Supreme Court that right now is in place. And I really don't want to tinker with the language that has already been accepted by these particular jurisdictions. And, you know, it makes it very difficult, Mr. Speaker, because to me, a life is a life. That's where I look at this particular legislation. A life is a life. If an infant comes out alive, that is a human being. That is life. And some of the previous speakers have rendered some statements that there may be sufficient legislation in place. Then, if that's the case, then why not reinforce existing legislation so that, in fact, we can codify it in direct reference to this particular activity as it applies to our island community. And I don't want to, I believe some of my closing comments will reflect on some of the statements that have already been made. But, Mr. Speaker, I object respectfully to this measure, this movement, only because of what I just previously stated. Thank you very much, Mr.
Thank you very much. There's been an objection. Any other senator wish to be heard on the amendment? Senator Pangilinan. After Senator Pangilinan, any other senator?
Thank you very much,
You're recognized.
Mr. Speaker. Mr. Speaker, I stand in support of the amendment. And I guess it's just from the perspective we have and how we read it. You know, the retiring speaker said, why not vote for 95 because it reinforces the federal law. Therein lies the dilemma for me. My interpretation is it doesn't. It extends beyond the federal law and the constitutional protections and rights that are afforded families and women, doctors and practitioners of medicine that are faced with this dilemma every single day. It does not reinforce. It goes beyond that. And in doing that, I think it interferes once again with what I would clarify as, in my consideration here, that personal domain that must be protected for the women who are faced with these decisions. So to say that somebody who votes for this amendment or who votes, you know, against Bill 95 is voting, you know, is inconsistent because it's the same as the federal law. It is not. But once even the proponents, you know, I read the testimonies given and justifications, and there's one of the comments that was made by one of the advocates for Bill 195, for example, was that, hey, even the most hardcore abortion advocates of the Democratic Party and the National Party, such as Hillary Clinton and Ted Kennedy, voted to enact this federal legislation. Well, then that's what we're doing here. we're voting then to ensure that the federal legislation that passed in the U.S. Senate is what we would put in place on Guam. And so it's almost as if to bait us into saying, oh, well, you know, I have to vote for Bill 95 or 195 because Ted Kennedy voted for the provision on the live birth. Well, I'll gladly vote for the provision for live birth as defined in the federal statute that respects that personal domain for the decisions that that take that personal domain and injects government into it by provisions of Bill 195. Thank you.
Thank you very much. Any other senator wish to be heard? Madam Speaker?
Thank you very much, Mr. Speaker. And I'd like to thank the mover of this amendment, because that's exactly what I've stated in my earlier discussion about how then this definition, based on, of course, the federal law, how it's all encompassing and how it could be applicable here in Guam. So it's being so anyway, I support it because I did say that this was something that I would like to do, not having the time, but I thank Senator Respicio for proffering this amendment, so I do support it.
Thank you very much, Madam Speaker. Any other senator wish to be heard? If not, I'll invite the proponent to close,
Yeah.
and then we'll call the question.
Yeah, thank you very much, Mr. Speaker and colleagues. Thank you for giving this amendment its due consideration. Thank you, Mr. Speaker, for recognizing that this amendment respects life, and respects life is without a doubt. Again, if what we're really wanting to do is take a federal code and put it in our Guam code annotated, then this is what we're going to do word for word. If there's something that we wanted to do otherwise, then we'll really see where the votes end up. But what I want to do at this point, Mr. Speaker, to give our colleagues some additional time to think about this amendment, I just ask for a couple minutes recess.
It's been a request for recess. Recess.